Dhananjay, in the meanwhile, I request just keep managing whosoever is coming and going. I'll take just very little time. So, hello and a very warm welcome to everyone. We very warmly and heartily welcome you to Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the tremendous, generous, and exuberant guidance, blessings by our seniors, guides, and mentors. Today, we have with us for a conversation Shri Justice Challa Kodanda Sir. He is, how do I say, one of the most fundamental persons who has guided us to where we are today. And I just want to, first of all, congratulate every one of you for just knowing that this is the start of the 100th class of Vestralex free online community classes on law. So just imagine the kind of generosity which our seniors have given and they have showered on us, through which we have come to this occasion. So before we start the class, a brief introduction by Ms. Monica for Justice Challa sir, and then we'll start with the conversation. So Monica, I request you to kindly please introduce.
Thank you so much, sir. Savi ko namaskar. Good evening, everyone. I welcome you all to the session today. I've been a moderator here before, but with your kindness today, Keshav sir, it is my honor and privilege to introduce our esteemed guests for the session, Shri Justice Challa Kodanda sir, who is a distinguished legal luminary with over 23 years of active legal practice in various courts across the country, including the high courts of Andhra Pradesh, Chhattisgarh, and the Supreme Court of India. Sir has an exceptional track record of arguing cases in multiple forums across the country, in major cities like Bengaluru, Ahmedabad, Mumbai, Bhubaneswar. We name it, we have it, with over 250 reported cases across diverse legal subjects. Born in the year 1959 in Challavaripalli, Andhra Pradesh, Sir pursued a degree in science at Satyasai College, Bengaluru, and later earned a law degree from Andhra University, Vishakhapatnam, in 1983. With early professional experience in the industrial sector shaping his skills, he enrolled as an advocate in the year 1988. Trained under stalwarts like Shri A. Venkataramaji and late Shri Justice S. Parvatrauji. He rose to prominence in constitutional remedies, contractual disputes, and commercial laws, earning the prestigious designation of senior advocate in the year 2009. He was elevated as an additional judge of the High Court of Andhra Pradesh in the year 2013 and subsequently served as the judge of the High Court for the states of Telengana and Andhra Pradesh from the year 2014 to 2021. In his judicial tenure, spanning 1,603 days to be very precise, Sir disposed of an impressive 18,890 cases, again to be very precise, contributing significantly to reducing pendency, in his own words, without any fear or favor. With a career guided by unwavering integrity and expertise, Sir continues to practice as a senior advocate and is a member of the Supreme Court Bar Association. With that, let us all welcome Sir as he shares his invaluable insights. And I'm confident this conversation will leave us all enriched and it's going to be a conversation that all of us take something from.
Thank
Over to
you.
you, sir.
Thank you so much, Monica. Thank you so much, Monica, for the introduction. But sir, Challa sir, very warm welcome to you. But sir, before I warmly, most humbly welcome you, I most humbly request for that one particular question which was there, that Monica, आप 6 महीने से आप Challa sir के साथ you're getting to work. How has the grind been?
Uh, I love this that he is enjoying this. Uh, well, I'll start off by showing this. I ran when he said he's going to ask me this question. I ran to get this so to show everyone his
Okay.
stats of every conversation with this particular book, The Law of
Yours
Success.
shows the law of success by
This is okay. I don't know
Recently
if
released.
it's clear. Yes, yes, yes. Is it?
Oh, fantastic.
Yes, yes. He has over 24, 40 books of this. I think the major business to this particular publishing house goes through Sir every year. He has a stack of books in this library and he gives it to everyone who comes to him. And so did he to me as well. I have a signed copy, the privilege to have the signed copy
Oh,
from
I
him.
want one too. I want one too. I want a signed one.
Yes. And then, yes, he overloads you with everything. Like he just gives you, you have to do these and these, you have to read these and these things. And then you're like, I don't know. I'm not sure. I don't know if I can read Contracts Act and Specific Relief Act at the same time, just, right away.
Certainly,
But
certainly. So,
then, of
Monica,
course,
that means it has been fun. That's what I'm getting, right?
yes, yes, it has
Yeah,
been
yeah, yeah. All right.
absolute fun.
So
I
that's a
recommend reading this book. And he
yeah.
will too
We
in
we'll ask
some
you. We'll
time.
ask you to come and give a summary one day. You'll make all of us. You'll make
No.
all of us to also learn.
That's nice. That's good. That's good.
So, Chala sir, it's how do I say? So, it's just a pleasure. It's just a privilege. How do I say? I just find it a blessing in myself. And sir, this the same thing, sir. The book that Monica just mentioned. Similarly, we had a class right prior to this with Tiku ma'am, Anjuli Tiku ma'am. She also emphasized on the need for reading. Then, sir, I see so many seniors also practicing here at Delhi High Court and all. I remember explicitly this session by Hari Shankar sir. He also he mentions very specifically that the relevance of books and reading. And everywhere, so whatever I've seen, sir. So, what is the relevance? How do so? How many books do you read in a year?
Oh, well, I can't really say how many books I read. That's a difficult question to answer because many times, many of us, we don't read the entire book. We read few chapters. Sometimes we read almost 3/4, then we read off. Sometimes we just flip through the content and sometimes we read the summary. But the most important thing is that the only way for you to know yourself and the society is through books. In that for that reason, I keep reading something or other. And of late, sometimes you get bored of reading or you get fed up of reading. Maybe also now there's another medium of listening, the audiobooks and also podcasts.
Just,
My
I
daughter,
request everyone to kindly keep the mics on mute, please.
recently, my daughter was sharing with me some podcasts, and she has allowed me to get into the Spotify, joined as a joint account. It's an introduction to. But many times I also keep seeing where YouTube. Oh, there he is. She is my daughter, Bharti Challa.
Oh, she's here. Bharti ji, namaskar. Very warm welcome.
I'll be
आपसे भी पूछेंगे आज पापा ने कितनी किताबें पढ़ाई आपको. And please, you can feel free to join in the conversation.
No, she has been reprimanding for not reading of late.
Oh.
So you need to have such lovely daughters who reprimand you for not reading.
Sir, I would love to know from them how is it to have a judge father.
Oh, you can have one of the sessions with many of the. I can cut off and bring you.
Are they both advocates?
No, she's still in the law student. She's studying in the third year law in Nalsar University.
Fantastic. Wish her all the best, sir. We wish her all the best.
Yeah. So coming back to our topic, the last question with which Tiku madam has left. Maybe we can go on with that to start with, and then as we go along, it can be a question answer format. As you rightly put it, time is precious. My understanding of the profession and the way I understood the profession is, as a law student, whether you have read or you are not read, you are a brilliant student and you are a studious student and you have read a large number of cases and case law, or the analysis or the jurisprudence. It may not really much matter at that particular point of time till you get a degree and you get qualified to be a lawyer. But once you become a lawyer, from the Indian context, I speak. Well, I'm not exposed to what is the law outside the country, what is the practice outside the country, or what is these opportunities outside the country. But from the Indian context, you just go back and study, say about 30, 40 years or 50 years of the way in which the legal profession has transformed itself from initial times of where only very well-read, mostly BA scholars. If you see, most of the time, in olden days, most of the lawyers, about 50, 60 years back, lawyers are all mostly BA, BL, BA, LLB. You don't find any other branch of people. Later came BSc people. Thereafter came BCom people, etc. Why the mostly BA people were interested? They were the people who were mostly studying social sciences. What is it they study in social sciences? The society. The society, how the society was earlier, and how the society is transforming itself now over a period of time. So when I started analyzing, I came late to profession, about 9-10 years late. After finishing my law, it's about 6 years. And in a particular state of mind, I came because I wasn't a very good student at college. Maybe I also wrote one supplementary in one of the years. I was also in the night college because I was working elsewhere. But once I came into profession, probably I had given almost every day 12 to 14 hours to the profession, because I was anxious to make good of the time which I did not spend earlier, that 5, 6 years or 7 years or 8 years of time. And also the lack of my reading in the college. Once you have joined the profession, that too as a late entrant, the need for earning on month-to-month basis puts you on an enormous pressure on yourself. So I can share without being ashamed of. My primary objective at the point of time when I joined profession was, how do I meet my monthly expenditure at the end of the month, or from time to time? And how do I get that? Seniors are not, we can't expect seniors to cater to your financial needs. Though today there is a lot of demand, and they say that as if it's a right, that the juniors should be paid this much of stipend, that much of stipend, and bar council should make rules, etc. It's your choice. You are entering into the profession. It's a different issue, like places like in Delhi or Bombay or in Calcutta or some of the metropolitan hubs, where there is a process, the practice of charging on a day fees, hourly fees, etc. But if you look at the large part of India, either in the district level or in the municipal level, the legal fees which an advocate earns, a senior advocate earns, is also abysmally low. That's for the simple reason, the clients, why will they come to you? You means not you, your senior also. Why do they go to their particular lawyer? If he is about 20 years or 30 years of standing, in a district headquarters, he has stayed for 20, 30 years. Or he is born, brought up there, and he has lived all his life. So over years, he has gone through the mill and he has made himself known to the public at large, which makes people to come to him. But at all the 20, 30 years of struggle, do you mean, is it that he has earned money, so much money? And in the beginning of his career also, 10 years or 15 years or first 15 years, even now you also can feel that. When you ask a question yourself, who are the people who come to you? And how do they come to know about you to start with? Somebody's chacha, somebody's brother-in-law, somebody's friend's cousin, friend. Without some reference, they are not coming to you. Or they are not coming to that senior. So there itself the discount starts of your ability to ask the fees, even for the senior. Forget about the Delhi Supreme Court, few of the people who can say that this is my fees and this has to be, the draft has to come this many hours before, and this is the note which you have to give me, etc. But in a majority of the lawyers, they come, your client comes to you only because you are known to someone, and someone to someone, and someone to someone. It's some connection. So that there itself, there's a discount starts. So really, one cannot expect, and that's the same thing with me, with my senior. So the point is that I realized that aspect of the matter at the very beginning of the first month itself. So to meet my expenses or to meet my this thing, I need to have my own clients. So as I said, how do I get it? I need to have the large amount of network of people who know that I am into the practice to start with. I keep joking with all my colleagues and my juniors. On average, you should distribute about 10 visiting cards per day. Saying that, okay, I'm a lawyer, I'm a lawyer, I'm a lawyer. The reason is, if say about 10,000 people you distribute, out of that 10,000, possibility of 1,000 people requiring legal services is also bleak. Out of that 1,000, 100 people keeping your card and keeping your this thing is again a chance. Out of that 100, 10 people coming to you is also a chance. Then out of that 10, the people who can pay and come to you may be about 1 or 2. So to start with, you need to have a large amount of, you need to, I can't say that you should get onto the rooftop and shout that, hey, I'm a lawyer, I'm available for hire. Because it's not possible and it's not permissible under the Bar Council rules. But you need to let the world know that you are available and you have an element of trustworthy service which you can give. Emphasis is on the service. And many a times in the initial period, you barely get anything. But at the same time, each time a client comes to you, the very fact that he has trusted you and he has given you a brief, you may succeed in that brief or you may not succeed in the brief. But you put all your effort into that particular brief. He has given you the fees by way of an opportunity to learn. It's like a medical student, in every medical students, especially in their final year and before they get out of the medical college, they love to have a dead body. Why? Because that ability to do the post-mortem, the live, I call it as a clinical material. For a medical student, clinical material is a dead body. Likewise, for a lawyer, clinical material is a case. So each time you get a case or a new subject or a subject which you are not familiar with, the very first opportunity is the opportunity for you to explore and experiment and be thorough with that particular branch. Once you have done that and he is the man has given you that opportunity, the second time, by the time the second client comes, you are well versed. Then when the very way you speak to them and the way you explain or the way in your conversation, you certainly make the client feel, yes, this boy or this girl knows the subject thoroughly. You have already started earning. That's what you are there for. Maybe second or third case. And mostly the satisfied client is the one who brings you again the other client. And how do you satisfy the client? Apart from the knowledge and exposure which you are able to demonstrate to him, they get diligently putting forward before the court. Before that, the drafting becomes very important. For you to be able to draft, it's not that a draft which is available either in Monga or in Bindra or in, recently one of the book which has been published online also. All India, all formats, etc. Formats give you only leaving the blanks. But what to put therein? For instance, in a specific performance suit, most important requirement is that if I am seeking a specific performance, that I was always ready and willing to perform my part of the contract, and these are all the acts which I have undertaken. Without that one pleading, everything goes for a toss. But you should know, no. Many of the interns who come to me, many times I keep asking them, okay, you're done, you are in a fourth year, you are in a fifth year, and they're all very, very excited, they young kids. They come out with lots of ideas and lots of things. They have done here, this law firm I have done, that law firm I have done. I ask them the simple question. Well, I give a hypothetical question of saying that, oh, you are likely to sue me. I come to know about it. So I go to my lawyer and I ask, I want you to file a suit against that other person, seek an injunctive relief against the other person, not to sue me. Where do I get it? Can I do it or can I not do it? What should I do? I don't say where do I ask them. And they say, yes, we have to file an injunction suit, blah, blah, blah. That means what? They haven't looked up the first and foremost, most important thing for a lawyer is not to see the, Monica was telling just now, the specific relief act. To a large extent, the specific relief act gives you what all the reliefs one can ask, what are the reliefs one cannot ask. But a law student, how many of them really have mastered and read the specific relief act? And in how many of the places or the colleges where they really place emphasis on the specific relief act for an youngster to know to start with his practice, unless he knows the specific relief act, he cannot do anything. He'll be running around this senior, that senior, etc. Even they may say that, okay, I have a particular problem. They say, all right, you have to file a suit. But suit for what? And what I should ask or what I should not ask, what is permissible, what is not permissible. Likewise, the Contract Act, basic, there are about 5 or 6 acts where you need to be really masters. When it comes to procedure, CPC, when it comes to the contracts, you should know the Contract Act, Evidence Act, and the Civil Procedure Code, CPC. Once you have those things, automatically you are confident about what you are doing. It's just that initial 6 months spending with your senior in an intense way, read the basics. That's where I'm thankful to my senior, late Justice Parvatrao. The very early stage, one client came and I ensured that the client doesn't go directly to the senior. Like I was like a Dwarapalka standing outside. And he came and I pulled him up and he said, come first, you discuss with me and then we'll go inside. So I very excitedly I called that man and made him to sit with me. He gave me all the details about what he wants, etc. Then I said, okay, this is a suit to be filed. I wrote what I called it as a plaint. Then I took it inside to the senior and explained to him. He said, okay, very good, very good. Then I gave him saying that what I called it as a plaint. He glanced it through quickly and then he said, what is this? I said, sir, it's plaint. He again asked me, what is this? I said, plaint. Then the next question which he asked me is, what is plaint? I said, plaint. He just looked at me and he laughed. I understood there's something wrong. I went back. Believe me, I still have that notes. Making a notes of what is plaint. First time it's true, no, plaint. What is plaint? Like that's the way my senior made us to learn, and we are afraid. Even if the commonest of the word, if I go, he will ask, what is it? So that the aptitude or attitude of the simple learning which you do in your school, what, when, how, whom, there are about 5 or 6 where these are so fundamental for you to be able to extract information from your client. But how many of us do that? How many of the youngsters really practicing, they come to the high court practice, they come to the various forums with respect to the, and there seems to be too much of emphasis on their ability to research sitting before the computers or the online research. No doubt online research, the research or the case law is something which in a particular facts of a particular case, something is which has been decided. But how do you know that particular, the same identical facts are there with you in your case? Even the slightest of variation can change. If there are 2 cases are alike, so identical, they don't require a lawyer. Today, your AI can do, ChatGPT can do, or your the investigation becomes very simple. It's just your ability to get into the nitty-gritties, what I learned from my senior, which he never accepted anything to be absolutely right. Everything it has to be questioned and questioned number of times. Thereafter, it's very easy. Once you are, once you have one satisfied client, he is the one who brings you another client and another client, another client. It's only that every time somebody gives you an opportunity to do a case, some may be able to pay, some may not be able to pay, but we should accept that first 5 years, this is the opportunity to do, as I said, medical student. Your ability to cut the corpse and know the anatomy well is what matters. The rest of the thing is only that it's a journey. And you need to understand the society. Now, that's very important. You need to understand the society and you need to understand the mind or the behavioral aspects of the people, so that you will be able to guide and you will be able to articulate before the bench. Because if you understand the judge, you know how to mold yourself. For which what is required is the keen observation. You are being in tune with the other person. These are all the few things. Probably anything else is required, I can probably, as an answer, I can give, rather than giving as a monologue. It can be a dialogue.
So, how do I say? It was just a flow that you went for, and it was really very meaningful and very relevant. So I think it resonated with everyone. So, a little, sir, since it's a conversation only, and sir, since we have your kind indulgence, so a little bit, if you can tell us, because that it intrigues me a lot that there was a long gap between when you completed your LLB and then when you started, and that you did it at a night school. So can you please just narrate a few bit of the circumstances as to what was happening, what was the journey of yours towards the legal profession?
See, I was not a very good student all through my life. In the sense, coming from, basically to start with, I come from a very basic rural background. And my father was an MLA at that time. And he had no time for the family or for the children. He was MLA from 1952. And for almost about 28 years. 1952 to 1978. And he is an old generation politician, an honest man. And he had no time for family or for anything else. And I happened to lose my mother when I was very young. So I grew up in my grandmother's place in village. I grew up completely in the village background. There are a lot of, in the village you have people around, and every alternative house is yours in a small village. Our village had a population of about 100, 150 people or 200 people. So I'm known in the every house, and apart from that, my father being one of the most educated person from that village, my father and my uncle, my other uncle, all of them. My uncle was also, he was a lawyer and former judge. Another uncle also was a lawyer. So educated family, emphasis was on education because my grandfathers did not study. So they had the thing. So within the result, a lot of people in my village were educated people. Interaction and the people skills and the genuineness. See, that's very most important thing when you grow up in the village. Not like today's, the olden days, it's even today in the villages, people are mostly playing. not much of calculative talk. They're just sincere and honest in whatever they say. And there's an element of pride in the village brought up. So that naturally carried, but when it comes to education, it will be surprising for many of you youngsters that for the first time we know about alphabets in English alphabets were learned at 6th standard. Both Hindi and English. Hindi starts at 8th standard those days. English for the first time in the 6th standard. So even today I am not so good in my English. My daughter keeps making fun of me. And in pronunciation, I said, okay, how does it matter? As long as I'm able to communicate. In the end, the journey in the just I studied my BSc. Thereafter, I went to do some work with somebody, and then in the process, I was having little time, and somebody said, "There's a night college law available." So I just applied for it because I could get it. I was working elsewhere. It was meant for part time. So I joined law and I completed 3 years. And thereafter, I continued to do my job and business. At one point of time, there was some setback in the business. I lost some huge money at that particular point of time. Completely broke, to be honest. So I didn't have anything else to do. I was just shifted from where I was there in that place to Hyderabad. One of my uncles said, "Why don't you do practice?" So I laughed at him, but I couldn't say anything to him. I joined the legal profession, and maybe you can call providence and luck.
Destiny, sir. We had to have this wonderful occasion.
Yes.
So it was for me, so that today I could benefit, and all of us, all of this manifestation of me, all of these participants who are just me, just like me, all of you guys, all the people who will get to see later, that we will get to learn through your experiences. Maybe that's what destiny had in mind. Then, sir, how was the initial life getting into law? Then all of this in the background. Then you step into the court. You start going to the court initially. That plaint incident also happens. So how was your first few years in the legal practice?
It was tough, actually, because it was actually about 10, 12 hours a day of working, and you are not thinking about anything else. It's just that every opportunity I got, I grabbed, and then I never bothered about whether I know this subject or I don't know this subject. I always used to say, what matters for me is that particular case which is in my hand. Not what is there in the books, not the theory. That particular client is the only one thing I know is this particular case and this particular client. Is a total, all your energies are put there. It's like you are a wrestler. Any number of bouts you must have done earlier. They are all only experiences. But what matters is on that day when you are in the pit, the punch which you are going to give or the punch which you are going to take is what matters for that day's win. So when it comes to the cases also, in one of the books where, I forgot that book, the name also, I lost it. It's with regard to the advocacy skills. What that author says is, however number of times you might have read your case, the day on which you are going to argue, that day morning you should read that file. And it is so true. I get flashes while I'm arguing the case. Suddenly, new idea crops in. Something new, why not you present it this way? And it happens instantaneously. And you find a few of the senior advocates I watch in the Supreme Court, I get fascinated. Like a person like G. Ramaswamy, I had occasion, good fortune to listen to him and observe him quite a number of times. The brilliant man, the way he was presenting his arguments and the way he was saying, exceptionally innovative. Like once he came in one of my matters to High Court. He had not read the brief totally. I tried to brief him. He said directly. Previous night when he came, he said, we'll do it tomorrow morning. Then morning, 8:30, I went to him. 8 o'clock, I went and sat with him. He was not ready. Around 8:45, he came out. Then he said, no, I'm sorry, I got late in the night. My friend, let's go for breakfast. We went for breakfast. I was, really upset in those days, and the case involved was about almost 100 crores. So I was completely scared what this man is doing. He's not looked into the file at all. We had breakfast, then he said, okay, get into the car. We sat in the car. While going to the court, the first question he asked me is, how is this judge? So I gave some information about the judge, saying that this man is this man is this. But I'm anxious wanting to tell him the thing. Then, okay, he said, I briefly told him a few facts. Okay. He came to court. What I told him that this judge is, he studied in London, he has done specialization in this, and he thinks that he knows the law very well. That's my assessment. And he thinks he's a brilliant man. Whatever I gave that. I also said he's a little more egoistic type of person, kind of my assessment. And I'm wrong or right, that's a different issue altogether. Mr. J. Ramaswamy is a very tall gentleman, almost I think 6'5", and very hefty personality. So the minute the judge came, the judge is short. The minute the judge came, this man, he bowed so much, almost parallel to the ground. And he stood up. Then the case is called. He said, Milord, he was an attorney general at that time. He said, I had to come. The fact that I came here, this is an argument. The fact that I had come on behalf of so and so, the client. It's a public sector undertaking. I put the first case as a public sector undertaking. Thereafter, private parties are there. About 5 people total. Total amount involved is about 100 crores. So he said, I appear on behalf of Government of India's company, so and so. I came all the way from Delhi. The very fact that I had to come for this, your lordships will take it that the case involves substantial question of law and fact. And I do not need to trouble your lordships for admission. I am sure that your lordship would appreciate and not wanting to be troubled. So it's a matter for admission is what he's conveyed. And the judge also said, all right. He didn't want to show that he is not a brilliant man. He said, all right, admit.
Issue notice returnable in 4
No,
weeks.
No. That's over. He said, he'll admit. Then he said, next to the argument is, very fact that when I say that the matter requires substantial issues, and as a matter of course, I can ask your lordships to issue notice and admit the case. When it comes to interim orders, I'm at your lordship's mercy. And he again bowed down himself to parallel to the ground. That's the argument. I said, what is this man is doing? He just said, I'm at your lordship's mercy. The judge said, all right. Then he said, your lordship put me on some terms of how much. Don't give me absolutes. You give me stay, but not absolute stay. You give me with some conditional. Then the judge said, all right, how much you want to pay? There was no discussion about what was the case, what was the subject, what was what. And in our High Court those days, there's no practice of judges reading at home and coming. So he said, okay, how much? And he said 10%. Then the other side was a notice they got up and they said, no, 50%. The judge said 50%. Then, finally it went on and haggling and on a payment of 30%. interim stay was granted. But that's a brilliant advocacy. He has not mentioned the facts, he has not told the case details, but that's the way he put it. I said, oh, this is what is advocacy is this.
So may I just share this one thought? And so you kindly correct me whether if I'm thinking on the same lines or not. I've seen in the higher courts, mostly High Court and Supreme Court, that at some point of time there is one argument by some senior advocate, very senior person, very senior person, and the argument is, "My lords will do it. I'm saying it. My lords will do it. I'm saying it. My lords, I'm saying it. My lords will do it." Sir, how is this argument, sir? I find it so fascinating.
No, you see, in the end, ultimately, what gets you going there in the court, that particular 5 minutes is what is matters. So your ability to connect with him, the judge, is what matters. You're able to connect with him or not. Sometimes, many a times, what happens is the higher courts, especially in Supreme Court, what I've been seeing, you are trying to tell something, the judge he's looking into some paper. He's not on with you on page. That 5 minutes, somebody is making an effort, Supreme Court and High Court. High Court, it's fine. Many times we have more time, but Supreme Court, you are trying to make out a point, but they are not in with you because already they have read, they have come with some element of some idea. In straight away, they can put that question and ask. Then you can answer, but they don't do that. They'll ask you, you start. The minute you start, they ask question. The minute you start the question. It goes off in the process. But maybe, they have their own time constraints and whatever, this one. But in high courts, you get a much better opportunity. And in trial courts, you get a lot of opportunity. It's how well you are prepared and how much of effort which you are willing to put. And the branches, over a period of time, in the beginning, I said you need to study the society. Why you need to study the society? The same problems are not there, what were there in the 100 years back or 50 years back. They are not there today. Each day or each time, as time passes, the problems in the society are varying. Problems in the society are manifold. So, end of the day, you need to find what exactly are the society's requirement, and then you need to tune yourself to that requirement.
Certainly, sir. So just so very few questions only. I'll want to keep. I would not want to take up a lot of your time, but just few questions, sir, that I think are of utmost relevance. At the same time, I request everyone that if you have any questions, please just share. So we'll just take them up also. So, sir, how did judgeship happen? One, and what were your how do I say such experiences? What are the kind of such experiences where you felt that, oh, this lawyer was very smart, he got that order even though I did not want to give him? So both of these.
No, also see, that's a very judgeship can happen for many reasons. Maybe in my case, for the reason, in slightly in South, maybe even in the North also is happening now. And especially if you read many of the Supreme Court resolutions of appointing judges or appointing this thing, they are nowadays, they are mentioning because he's so and so backward class, the proposed representation is to be given, blah, blah. That's why we are selecting him. Personally, I don't find it in good taste. But okay, after all, they are lordships and they can do what they want to do, and they are the people. I have no control over it. But as a matter of fact, it happens in many of the states. So in South, when it came to my particular time, they need to select from each of the segment or whatever it is. They were looking for good practicing advocates, etc. So some of the senior judges suggested, when it came to my community, Chaudhary community, which I belong to, they unanimously my name came up, saying that he has a lot of work and he has this one. And earlier I had refused. But still, if you are able to convince him, you can ask. So I had an opportunity of becoming a judge in 2004. I refused. Thereafter, again, one more time or two times, again, I had opportunity. I wasn't keen. But in 2012, Justice Lokor and Justice Goda Raghuram, both of them persuaded me. And reason, the way they persuaded me is different. What he said is, if the good people are not sitting in the chair, bad people will sit in their hands, your children and your society will be there. So to ensure that your children and your society is in good hands, good people should accept office and they should be willing to sacrifice their own personal gains and do their bit to the society. That motivated me to accept my office and go forward. I have no regrets.
So absolutely. So I think it is, being a judge is one of the biggest sacrifices a person can do for their lives. So I see the Supreme Court also, where I see the grills for the main court building. I see that as the jail in which the judges put themselves. They cannot roam around freely. Judges cannot do anything. So high courts also, it's life, family, friends, everything is lost. But sir, again, so sir, deepest gratitude to you and to all of the present and past judges who have given their lives and careers for all of this.
Yeah, there's a great drill for the judges, to be honest. A lot of sacrifice on their part. It's not that it's easy, though it looks like as if there's not much of a easy life. No, it's not an easy life. If you study an average, a good conscious judge, either in the High Court or in the trial court, it's almost about 14, 15, 16 hours to 18 hours a day. Maybe physically you don't see them doing that kind of this thing, but what happens is, you get into the role, your mind is totally preoccupied. 24 hours you are thinking about that, you are only into that. And you also don't know after a particular point of time anything else other than what is anywhere you are there in the this one, your law or law related or some case related. It just happens.
And so everyone wants to be friends for some kind of benefit only, I think.
No, not only that, even if the friends also, with the friends, what is it you talk about? Because you are 24 hours, you are only in this particular field. So even what you can tell is, that day this happened, this in this case, that happened, in this case, that happened. You can tell your stories. They get bored, but they also put up with you because when they tell their stories about their work and their this thing, you also listen. It's not that like now many of our friends who are on the online, it's only because you see that's what they are used to it, and it sounds very familiar for them, and they also feel comfortable. You are in the comfortable.
Actually, what we want actually, sir, today is Delhi High Court's last day of like before the vacation.
Yeah.
And so that is how we thought also. We understood that there would be challenges for a lot of people because it's a weekday, first of all. Classes started 3 p.m. and as of right now, also people are going back home only. So everyone told me certain challenges would be there with this. But so I did not see any other element of moving forward because there was no point disturbing anyone during the vacation, and that too this time around. So I was like, okay, let's till today, let's just somehow try to make it happen. And so it was just so kind that you could give us this time today. It was one of the most valuable things which has happened. And so specifically for this class, considering that it's a 100th class, it actually I don't know so how it happened. I did not expect that we would reach this number. So I'm just very humbled and very grateful to you in that respect. So one incident, sir, but I most humbly request of you, sir, of one incident for anyone who's referring to this video probably at some time, maybe in lighter vein, that you truly enjoyed sitting on the bench. You don't have to give names if you don't want to, nothing at all, no particular, but something that you enjoyed when you were there on the bench.
Well, as so far as I'm concerned, my personally, I enjoyed every day and every minute for the reason, one is that, I know that this particular point of time to this particular point of time, I am duty bound to be there and I'll be there. Committed myself to be there. Number one. Number two, as I said, each case is unique. There are no two cases alike, or there are no two, the litigant public who had come to me are alike with the same problem, though there may be similarities. So when I was, my micro level, I was trying to solve their particular problem. I'm not, if you look at my judgments or what I have done, I was only trying to cater to that individual, make that individual who had come to the court happy and see whether I can do something for him. And in that process, again, also trying to being in the understanding the level in which I'm required to do. In a few of the cases, yes, I was trying to set an example, or I was trying to lay down a particular proposition which is already not there. Like today morning, in fact, with regard to one of my own, one of my family members' case, I had to tell one of my colleague to look up so-and-so judgment. In recording of evidence, of late there is a new practice has developed in the courts. Youngsters not knowing the scope or study. Evidence is recorded of the plaintiff, or evidence is recorded of the defendant. Then all of a sudden, plaintiff counsel realizes that there should have been so many questions I should have put to the plaintiff, or defendant counsel realizes I should have cross-examined the plaintiff on these lines. I have not done. So he goes and files an application saying that reopen evidence and recall the plaintiff for cross-examination, further cross-examination. And some of the judges, especially the junior level judges, and even some senior civil judges, what is there? One more opportunity to be given. IA allowed. And one of the questions which came before me, somehow I wasn't very convinced about that. I looked up, I went back and studied. To my surprise, I did not find even one case with regard to that, except one Supreme Court judgment where Supreme Court allowed, all right, let it be done. And without reference to the legal principle. In that particular facts of the case, Supreme Court said you do it. Because if they are 142, they can do anything. But then when I looked at the procedure, both under Evidence Act as well as under CPC, I found it is impermissible. Because the sequence of examination of witnesses is first plaintiff leads his evidence. What are this thing? What he has to do? Affidavit, the chief examination. cross-examination, re-examination. Once the re-examination is done, that witness is over. I could have put that question at that point of time. I forgot to put, I have not done my homework, I have not looked into that. So reopen doesn't arise. That tells the advocate how well he should be prepared before he goes for evidence, recording of evidence. The thorough homework which he is required to do, and the discovery which he is required to do. The CPC provides for interrogatories. CPC provides for discovery. You have to use pre-trial homework. Then you go to examine the lead evidence. But when I looked at that particular aspect, there was no judgment. So I said, okay, let me put the precedent. I have to create a precedent. So I created a precedent. It just happened today morning again. I needed that for one of my cousins' case. So I just looked up and I was being amazed. Likewise, in few of the places, wherever there was an opportunity for me to make a dent, and otherwise it's very easy for you to, if you really, there are two kinds of judges. You can always say, quote, and I conclude. I don't want to name one of the Supreme Court judgment, he's no more. But if you see in his judgment, it's an encyclopedia of all previous judgments. At least we would have referred to every judgment. You don't need to require to read any other judgments. Go to his judgment and you will find everything. But many a times the danger there is, you would have only selected a few portions of that particular judgment which suits that particular case which he is deciding. If you are not studied, or if you are not read every judgment of what has been referred to there, many a times you may really miss the question. Fundamental question one needs to ask: is it necessary for so many judgments to be referred to? It's a burdening. That's where the emphasis, too much emphasis on the judgment law. It's not even judgment law. Each judgment is only, in my personal humble opinion.
No, but sir, 250 reported judgments while you were practicing at that point of time. I can only imagine the kind of work that would have happened when you were judge.
No,
18,000 cases.
We had a great opportunity of the judges who were appreciating every time a new issue, new point, new angle is raised. And we were, that particular point of time, every day we were challenging something or other, and judges are also, it was a great challenge every day. In the sense, it was a very exciting times for us. In fact, I always, many a times I told in the bar also, unfortunately, none of you people are really not looking in depth and coming back to the judges, challenging our intellect and our knowledge. You are meekly supporting and wanting to take an order and go. I call it as consider and dispose of jurisprudence.
Consider and dispose of.
Yeah, they just want, okay, please direct to consider my case and dispose of a main writ petition. We are satisfied with that.
We are disposed of in 5 minutes. It will be expedited. So I can only imagine, sir, how it is actually on the other side of thing. But sir, honestly, I'm very scared of it. I think that it's a very, very big task, what you have done as a judge, what all of these other judges are doing also, what people have done for so long. Because everyone comes to you, because, sir, I'll tell you, sir, when I had started doing law, at that point of time, I was told that the reason why judges are called lords are because they are the manifestation of God on earth. So this is the idea with which people look at the bench. And honestly, sir, from what I gather, this is exactly how it is, frankly, that if God cannot be in person, if he cannot be on the ground, then whoever are the people who are chosen to be judges, those people have that responsibility. All their happiness, everything, sir, everything depends upon that. So it's a बोलते हैं naman, sir, naman है आपकी उस बहुत ही कैसे बताऊँ आपको, sir was saying about what he thinks of judgments before you interjected in the topic was lost. Sir, I'm so sorry, sir. So there's a comment from Dhananjay Gupta. I'm sorry, sir. I just wanted to compliment you.
Oh, what is it? What is brother said?
So he has said that sir was saying what he thinks of judgments before you interjected and topic was lost.
Oh,
तो धनंजय बता दो कौन सी जजमेंट के बारे में क्या बात थी, तो थोड़ा हमें भी एनलाइटन कर दो.
No, sir was saying, sir, hello, sir. Firstly,
yeah, Mr.
good evening, sir. So you were saying that what you think about judgments in terms, some topic was going on.
Yeah, some topic was going on.
Many of the judgments are opinions,
Yes,
are not interpretations.
yes,
Because if you look at the provision is there just in 4 lines or 5 lines. When you read the judgment, it runs into 20 pages. What is it they are writing? It's an opinion of the judge, depending on in the case in which he is dealing and that particular facts of the case. That's where I am grateful to my senior who said that no judgment he accepted as absolutely, this is the law. He said, see, look at the facts in that particular case, in that particular fact situation, in that particular circumstances, that opinion is rendered. If in my case there is a slightest of change in the facts or slightest of change in any of the surrounding circumstances, that judgment is no precedent for me. And it is so true. The fine art of understanding or fine art of making the distinction in the judgments is that your ability to see what was the crux of the matter decided there and what was the issue and what was the provision interpreted. If the provision is not interpreted in that particular facts, the judge felt to give relief or not to give relief. That's all. How can that be precedent? That takes you to the advocates to ask yourself, what is precedent? That's where I tell you, your ability to do a little bit of computer research is neither here nor there. Because it really doesn't help you much.
Okay, Dhananjay ji, does it suffice?
I think sir has concluded the topic.
Was this judgment of sirs as per your whims and fancies, or do you want to go in for appeal?
No, certainly. The exact point the sir has absolutely covered that it is the judgment what is the court delivers in the given facts and circumstances, and only it can be applied in the if the exact facts and circumstances apply to it. Otherwise, if there is slight change, then ultimately it is the only provision of law that has to be seen whether it applies to or not.
So it gives a great challenging task for an advocate to be able to swim out of this plethora of judgments. Every day they are producing so many hundreds. You on any topic you just put a button, you will get 50 judgments, 100 judgments. Then it's always possible. You see, I see youngsters every day bringing lots of judgments, saying that this judgment, that judgment. I said, you are searching for a needle in a haystack.
True, sir. It's so kind of you to actually acknowledge the plight of the young students. So I'm sure that Miss Monica will also feel better
the
next time she is able to find
the guidance which they required to get, which fortunately I had from my senior.
So
the senior should be able to guide and tell what exactly he is looking for, or how to look. So, that guidance provided the junior is willing to follow the senior and understands the.
Absolutely, sir. Absolutely. So today, sir, juniors are not sticking around for a very long period of time because there are a lot of seniors, sir. We had a class with Mohit Mathur, sir, a while back. He's president of Delhi High Court Bar. He mentioned very clearly that I think over the past 1 year or so, I think he mentioned, I'll just cross-check and verify to you, 1 or 2 years, he mentioned that there are 10,000 new advocates who have enrolled in the Delhi High Court Bar itself.
Yeah.
And so so it's just very difficult for all of these people to first of all get accommodated. If every single year something of this sort is happening, then how many seniors will accommodate so many juniors also? And then if there are mandates to pay them also, then how will they do that? So it's a
So,
very interesting thing. So there's one final parting words I request of you, sir, on one particular topic. So as you very rightfully said, but this particular concept, and thank you, Dhananjay, for bringing us back to that particular topic, that there is some clarity with respect to judgments now as to what one should expect from them. So just one question from you. How it is expected today? Like we were having a class, I think with Shri S.S. Naganand, sir, from Karnataka itself. So he mentioned one very interesting thing that Keshav, when we were younger, the draft used to be very small. He was like for a bail application, it just could not go over 3 pages. Like 2 pages what was max, and 3 pages was like the limit. And today, sir, I'll be very honest with you, sir. In the initial few, like when I started my practice, at that point of time, sir, one time I filed a 40-page bail application. I don't know what was in it. I got the bill. I got the bill. No? I got the bill. Maybe because the judge did not want to read. Like, who is this guy? It's such a small matter. Why is he so troubled about it? Okay, grant. Okay. But sir, and sir again, so now if we're trying to prepare for, let's assume, the AOR examination at Supreme Court, over there also, so the first case which is mentioned is Keshwanand Bharti, 1,000-page judgment. Now, sir, are people really expected to read all of those? A and B, and so all judgments I'm seeing 75 pages, 90 pages, 100, 200 pages, like that's the thing that. But sir, is a person expected to read all of those such judgments? One, and second is that so what should be an ideal judgment page size? Like how many pages may it ideally run in? Can it be like small? Can it be like that
Can
draft?
Keshav, can I add one thing to your sentence?
Question, हाँ धनंजय, add
No.
करो.
Okay, one thing is whether and how to read it also. In case if it's a 1,000-page judgment,
हाँ.
whether to read it entirety or you have to pick and choose from where to read and what not to read, and some sort of, so that you can cover up the entire judgment.
Sir, Harry Potter biggest book was 1,000 pages.
No, so that you
J.R.R. Tolkien, Lord of the Rings, their entire novel is I think 1,100 pages. And sir, this is legal language. This is not simple. This is 1,000. This is like 10,000 pages of those books.
by the time you come down to the 20th or 30th page, you lose the essence of the from where you started. Sometimes it happens.
no, see,
Please.
it's a different. So far as reading of the judgments is concerned, it depends upon the purpose for which you are reading. That's number one. And also the need for your need, purpose and your need. Take for instance, just now you all had the benefit of listening to Professor Tipu Madam. She as an academician, she as a teacher, she has a requirement of reading entire thing and understanding the essence and what is the purpose and what is the philosophy behind that judgment is required to be told to the students and educate the people. Okay. But as a lawyer, arguing lawyer, your case, what is it you require? You require that in this particular case, principles of natural justice violated. Principles of natural justice violation shall not be tolerated, or that is a ground for interference, is the settled law. Where is it settled? In the earliest judgment, it is settled. If you look at the judgments, and without there being a disrespect to anybody, there will be one first judgment in which there's some 50 years back or 100 years back, somebody has laid in one line or two lines that principle. Thereafter, somebody else, while referring to that judgment, what he understood as that principle, he wrote in another 4 paragraphs. Thereafter, somebody quoted that and this, and then he explained it 6 paragraphs. You know, they multiplied. But if you look at, in the end, what exactly is the Ganga kahan se bati hai? You know, say that where does the Ganga start from? The source. Gangotri ke paas jana hai. By the time it comes to Haridwar, see how big the Ganga is and how much the water is flowing. But if you see at Gangotri, you'll find, Are, yehi hai Ganga.
Oh.
You say, this is the problem here. Your Keshwarananda Bharati or your these things, so far as a student of law, as a philosophy or as a lecturer, yes, they are required to read the entire of the things. At that particular point of time, you are already done with it, and then you understand in the entire essence of what is the Keshwarananda Bharati's essence. Essence is that basic structure of the constitution.
Sir,
is
itna likh dete bas.
Unalterable.
Sir, itna likh dete bas ki guys, this is basic structure. Please, this cannot be altered. Order. Then, sir, we are all there to follow. We will be like, okay, cool. Let it be cryptic. Irrespective, sir, 1000 pages is also not, it's not less cryptic, sir. 1000 pages is more than cryptic, to be honest.
No,
With utmost due respect to so much effort that would have gone into.
Likewise, when it comes to principles of violation of principles of natural justice, a real full judgment or the earliest judgment. So that's why whenever I'm faced with these kind of things, what I do is I just go back to the source and the first judgments in which the real principle has been laid down. And whether there is any variation to that principle in later judgments, which may be suitable or which may be go against me, is what I try to locate.
Certainly, sir.
It's possible for you to read everything printed in the today. And if you guess, that's the reason I again go back to that, and you see what is interpretation, what is the opinion. You need to understand that particularly. Once you understand that principle, whether this judgment has interpreted the provision or in a similar circumstances, the judgment is only rendered a finding with regard to that particular case. And in the opinion of the judge, that is important again. In the opinion of the judgment, that client should be given, that particular petitioner should be given relief or not to be given relief. In that takes you back to your understanding of what is a precedent. That takes you back to understand what Supreme Court said or what the earliest it is said. What is a precedent? Precedent is only an interpretation of a provision, not opinion. The opinion in a judgment is not a precedent. Yeah, precedent in a loose sense, because you preceded me as a lawyer. But here, when it comes to legal sense precedent, it is only the declaration of law is a precedent, binding precedent, not opinion.
Certainly, sir.
See, this
so how do I say? So
particular thing, automatically everything will fall in.
So, but so there is one thing which comes out of this. That's next time, so I really very most humbly and sincerely request that there may be probably a session on precedents. How you mentioned right now, the opinion as well as the finding in the matter, any judgment for that matter of fact. So similarly, so we had a class with A.K. Ganguly, sir. He mentioned very specifically on obiter dictum. So similarly, if we can have the good fortune of having one day to learn just about judgment, just about precedents from you, and what is how you mentioned right now the entire hierarchy of understanding, learning, etc., etc., etc. So, so we've taken a lot of your time, actually a lot much more than what we had asked, but it's just that you're kind enough. I was just looking at
I should thank all of you for patiently listening.
No, sir, it's a blessing. Actually, sir, just before the class ends, sir, I just want to most humbly introduce you to Bharat Lakshmi ma'am. Ma'am, can you please unmute, ma'am?
He was my bar member, na?
Oh, ma'am, that's
Sir,
great. That's
good
great.
evening, sir. Namaste, sir.
Namaste, ma bhavana.
Namaskar, ma'am.
Bhavnan, sir. Bhavnan, sir. Sir, can I have a doubt to clarify about the cross appeals? From one suit, they preferred two appeals from both sides, sir.
Appeal and cross appeal again. One more round. That's all.
Both are same. Now it's coming for final hearing. Both are at a time, sir. One appeal filed by my client after their filing of appeal. Which one should be heard first?
Claim ledamma, if you look at the
Sir,
suit,
sir.
in a suit, appeal and cross appeal,
Yes, sir.
it all depends on what kind of suit it is.
Okay. Suit for maintenance filed by first wife, sir. And the second wife, they are claiming that in group insurance and pension or whatever the monetary benefits for that. Even first wife died, he left a will on behalf of his niece, brother's son. She don't have the children. She left the marital life as early, and after that he got married and he's giving the maintenance. And he left. He died, and she also died, sir.
Insurance is again, see, that is again, insurance law is different. Insurance policy is a contract.
Sir.
Insurance policy is a contract. Whatever contract document mentions,
sir,
should go.
Sir.
Suppose he may write it in favor of a dog. In his dog, he's fond of his dog, and he may write nominee or my proceeds of my insurance will go to my dog. He can write that. It all depends on, because that is an independent insurance is the contract. Basically, it's a contract, either life insurance or the regular insurance. That's why they call it as a contract of good faith.
Sir, here my doubt is, sir, with about pensionary benefits, the person before write a will nama after
that's what I'm saying. See, pensionary benefits again, they are all basically, it all depends on the rules.
Sir, sir.
I really can't give any straight.
Yeah, ma'am. Actually, because it will be very difficult from what I am understanding, that it will have to be read, and something will have to be only then come.
It depends on your service rules and the organization in which they are working, and also the restrictions which they have. Then again, it also goes back to legitimacy of marriage and not legitimacy of marriage.
Okay.
And whether they are entitled or not, and there are so many judgments, judgment law.
Yes. Okay.
Judgment law also.
Sir.
Whether nomination binds and whether they are other than wife and first wife or second wife or their children, who is entitled to declarations they give in their forms while service law.
Yes, sir.
Somebody can say that marrying a second time is against the service law. So you are not entitled for pension at all. There are 101 arguments which can be advanced and which have been advanced. But that requires a deeper study of particular case.
Yes. So thank you so much.
We'll be able to look up and help you and guide you in that.
Thank you so much, sir. I'm waiting for that only. We are blessed because of these community classes introduced by Keshav. He is taking care of every year. Community classes are going. Today is very, very happy for me, sir. Really having your blessings and advantage of.
So may I most humbly submit that in these 100 classes, there is one class of Bharat Lakshmi ma'am also. And sir, it is one of the most fundamental classes, and one of the one class which is closest to my heart, because that class it happened in 2022, I think. Ma'am, one it was 22 I think it was. 22, and in 22 we were doing this one particular initiative wherein in that particular, now we're doing scattered classes. Then sir, we just had a devised mind that we will cover all 25 high courts in 13 weeks over 13 Sundays, every day 2 classes. So the second class itself was Bharat Lakshmi ma'am's, and she was representing Andhra Pradesh High Court, and she spoke on the topic of the legal profession for women. And I remember, sir, the insight that she had shared in that particular class. They were some of the most eye-opening elements for me at that point of time, and very fundamental to whatever learning I could or have today. So, Bharatlakshmi ma'am, thank you so much to you also, ma'am. So, just
We have to thank you. Thank you so much, our Kodandram sir, giving opportunity through your our platform. So very happy and thank you. Nice.
Thank you, everyone. In fact, I'm humbled for the patience.
Sir, call చేసి కలుస్తాను సార్ ఒకసారి వస్తాను సార్
Okay, ma.
Thank you, sir. Thank you, sir.
And Challa sir, I just cannot put in words how much it means to not just our participants or our team, but all the people who will refer to this video in the future. And I think for everyone forever that this particular session, the 100th session, it had to happen with you. And
thank you. My privilege. Score bana diya.
Is it 100th very
century
happy.
Sir, आपने आते century मारी sir आपने.
Very happy.
I should thank Monica also for
so yes sir. She prepared that and she delivered it very well actually, sir. She delivered it very well actually. I am happy, sir. I am so proud that Monica is working with you now. So it's
very great introduction, sir. మిమ్మల్ని మేము అప్పుడు ఆ రోజు ఇన్వైట్ చేసినప్పుడు కూడా ఉన్న హ్యాపీనెస్ కన్నా ఇప్పుడు ఇంకా చాలా ఎక్కువ హ్యాపీనెస్ ఉంది సార్. ఎలివేషన్.
I'm also happy.
Yes, then I was a treasurer in our association. Keshav.
Yes ma'am.
We invited sir to elevation, and sir is my senior's friend, close friend.
Oh, wow.
Day to day we met him and we missed him. Then sir, how now he's also as it is same after long period also, after he's becoming judge and whatever it may be, sir will be same always. Every moment he enjoys and invites us also to have happiness.
The motto. In fact, you asked how do you do the work? In fact, simple. Each case you enjoy. As it comes, you enjoy. That's it. Be in the present.
Sir.
Eckhart Tolle.
So what does it mean, sir? What is that, sir?
Now, see that there's a book called Now. N-O-W.
N-O-W.
Yeah.
N-O-W.
It's called, sir, how is it pronounced in
N-O-W.
N-O-W. Okay, is that all that
Now.
I thought you said something in probably in Andhra language that that
No. Or the present. The present you can
I don't know. I thought I heard two words combined and it was very intriguing. I thought, okay, let's learn something new now.
No. The present you can give is the present.
The present that you can give is the present.
Yeah.
In sir's dictionary, I mean to say I can interpret as O for sir, open heart. Sir is very like nothing as open heart. That's all. Sir always open heart.
Big heart, very big heart, sir. Very big heart. It's the blessing.
Thank you, Keshav.
Done, sir. Done. Very kind of you, sir. I seek your permission to end this class.
Thank you, everybody.
Thank you so much, sir.
Thank you so much to everyone who's participated.
I should thank everybody for their patient listening to me. Something good, something bad, something relevant, something irrelevant. But let me tell you, whatever I have done from my heart. And
yes, that's so open heart. Thank you so much.
Yes, for you, sir. It's your heart, sir. So kind of you, sir. So kind of you, sir. Thank you so much, sir. So, sir, with your permission, I'll end the class now.
Yeah.
Yeah, please. Nice time.